The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Hi, I'm Kevin O'Flaherty. I hope you enjoyed this Learn About Law video and podcast presented by O'Flaherty Law. If you need some help, please feel free to give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several locations for your convenience. Thank you so much for watching and listening.
Hi, this is Andrew with Learn About Law, and in today's video we're going to be discussing some of the common problems with evidence presented in a child custody case in Illinois. So ideally we hope that child custody cases progress smoothly, with each side agreeing on terms and putting their child's best interest first. Avoiding drawn-out litigation saves money and emotional stress, but sometimes both sides are out for blood and the process can be complicated. Anything from witnesses, documents, videos, etc. can and will be entered as evidence in support of one side or the other. However, there are instances when a given piece of evidence will be problematic, usually for legal reasons, and risks not being considered in the case, even though it would be beneficial to one party or the other. Some examples of problems that arise in the evidence process with pieces of evidence include exclusion of witness, child witness, past recollection recorded, failure to produce evidence or witness demonstrative evidence. Then you've got exhibits, foundational proof, there's hearsay, proof of facts, and then the Fifth Amendment. So let's talk about these, right? So first we have exclusion of witness. In this scenario, one party is requesting that the court order the exclusion of a given witness so that the witness cannot hear the testimony of other witnesses. Requesting the exclusion of a witness has long been used as a way to expose fabrication, inaccuracy, and collusion. However, in order to exclude a witness does not guarantee exclusion in the following scenarios and would have to be strongly considered by the court. So we have what's called a natural person, right? So this is an individual human being as opposed to like a legal entity. Then there's an officer or employee of a party that is not a natural person, i.e. a legal entity or business. Then you have a person who is designated as an essential presence to the party's cause. And then lastly, you've got a person authorized by the law to be present at testimony. So second is a child witness. The main point to remember with a potential child witness is that age itself does not determine competency. So whether a child will be able to act as a witness is determined by evaluating the child's intelligence, understanding, and moral sense. Another issue that might arise in evidence is what's called a past recollection record. This refers to complications with regards to recorded information and the witness's knowledge of the recorded information. In Illinois, the prerequisites for admissibility as past recollection recorded are going to be the witness has no recollection of event or recording of event, written reports fail to remind the witness of the event or recording, and then the timeliness of facts recorded in the report. Generally, the recording should be at the time of occurrence or shortly thereafter. Truth and accuracy around the timeliness of the report has to be verified. A fourth type of problem would be failure to produce evidence or witness. So failure to produce a witness can be problematic for multiple reasons, and either party may have a reason for not producing or calling a witness. So two common issues are going to be if the defendant's party calls no witness, there should be no presumption that if that witness were called, his or her testimony would be unfavorable. Two, there should be no inference of adverse testimony if there is a reasonable excuse for the witness being unable to testify. So in order to mitigate the impact of missing witnesses on a case, instruction from the court on missing witnesses can be given when four factors are present. The witness is under control of the party to be charged and can't be produced. For some reason, the witness is not equally available to both parties. Third, the witness's testimony would be helpful, but he or she was not produced. Fourth, no good reason for failure to produce the witness in general, right? Also, there can be problems with demonstrative evidence. Because demonstrative evidence is not an actual real piece of evidence, but rather, let's say, an object, presentation, diagram, or some other type of educational aid, the court must decide on its admissibility. Then we've got exhibits like foundational proof, or are another area where issues arise. So foundational proof refers to proof that lays out the groundwork for the credibility of a piece of evidence or exhibit. So for example, a business record or a profit and loss sheet. It is the court's responsibility to scrutinize the value of an exhibit and the foundational proof associated with it. Then we've got hearsay. So hearsay is evidence that can't be adequately substantiated, such as a report of another person's words by a witness or letters written by a doctor who was caring for a minor involved in a given case, right? Next, we have proof of facts. As the term implies, we're dealing with whether a fact can be proven and if it's absolutely necessary to be proven in order to be considered by the jury. Some examples of issue regarding proof of fact are going to include things like a fact may not actually need to be proven by evidence if well argued and without denial by the opposing party. Stipulations around a fact are ideally clear, evident, and certain, and assented by both parties and their lawyers. Third, you've got courts often look with favor on any stipulations that may shorten the length of litigation. This could maybe possibly introduce bias into evidence consideration. A lawyer may interview normal witnesses but must seek consent before interviewing a treating physician, or the lawyer may violate physician-patient privilege. Our last big problem here is the Fifth Amendment, right? Most of us have heard the phrase, "I plead the Fifth," but we don't really understand what it means. So in defense, pleading the Fifth is basically a way of saying, I can't answer this question or give this evidence because it may incriminate me. So one can see how this could quickly complicate access to certain evidence in a case. However, action can be taken against a witness who pleads the Fifth on grounds of self-incrimination if there is other evidence that exists to support the position of the opponent. While this list is not exhaustive, it does include some of the more common evidentiary considerations in child custody cases in Illinois. Both parties must understand that not every piece of evidence they think should be included will make its way into litigation, and conversely should understand that things they want to keep out of the litigation process may be forced to be included. For more information on child custody laws in Illinois, check out our article, Illinois Parenting Laws 2020, up on our website. And again, thanks for tuning in.
Hi, Kevin O'Flaherty again from O'Flaherty Law. Hope you enjoyed our presentation of Learn About Law. If you need some help, please feel free to give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. If you found this helpful, we'd love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.